Welcome to the Yunusov Question. I am Pulat Yunusov, your host. I interview lawyers and judges. This show is supported by my law practice, Yunusov Law Professional Corporation. I am a commercial litigator. I've done nothing but litigation since 2011. Many of you know me or my work. I would really appreciate your referrals. They are safe with me. Thank you and enjoy the show. Hello, everyone. This is another episode of the Yunusov Question. My guest today is Monique Jilesen, Managing Partner, Lenczner Slaght LLP, Toronto. Hello, Monique.
Hello, Pulat. How are you?
I'm very good. I'm very happy. I'm very happy to have you on the show. And I can't wait to talk about the many things that interest me. I interview all kinds of lawyers, mostly litigators, but I'm a commercial litigator, so I feel most affiliated to you, and I will have some questions to you that I hope to put to use in my own practice later. I usually start with how the person grew up, where they come from, and things like that. We all want to know about where the person came from. And I told a judge recently that one of the reasons I asked my guests these questions is to prove to the audience that they're human, that judges are human, right? For example, and in your particular case, when I went to your law firm profile and I started going through the cases tab on the details page about you, it just kept going on and on and on and on. And then I clicked more and more and more. And I seriously, like for 5 minutes, it wouldn't stop. So I think it is even more imperative with you to prove that you're human, actually, because you did so much in your 22, right? Years of practice.
I guess, yeah, well, good. I was called in the year 2000, so I guess we're into year 23 now. It's hard to admit.
Yes, it's the year 23 now. So let's definitely try to file a proof of human here. So where are you from? Tell us about your place of birth and how you grew up.
So I'm very human. Let's just be clear about that. I guess it's sort of a long story and a short story. I was born in Ottawa. I think people find my story of interest. We actually told it at the firm just before the holidays, before I became managing partner. I actually, I don't mind telling you and your listeners, but at all about my story, but I'm a weirdly private person. So I actually don't, I guess I now just have to get used to it, talking about myself. But I was born in Ottawa of a single mother. We lived there until I was 5. And my mother was a nanny. So we, when I was born, or I presume before I was born, I don't really know. I wasn't there. I guess I don't remember what happened when I was born either. But the story as I know it is that she was hired to help support another family where the mother had epilepsy, which was not well managed at that. Now we're talking, I won't, when I was a baby, more than 23 years ago. And so we lived on the 3rd floor of a house in the Glebe in Ottawa, where she took care of me and my friend, who ended up becoming my friend, but the child of the family in whose house we lived in, and she took care of both of us. And as I said, we became great friends with that family. But those were my early years. And then my uncle was, so my mother's family lived in Oshawa, and my uncle became sadly very sick. So my mother moved back to Oshawa with my grandparents and my uncle to help support the family through my uncle's illness. And so I grew up really with my mother and my grandparents and my then 3 uncles. Sadly, my youngest uncle passed away after that illness. And so I was raised really by that was my family, my grandparents, my uncles, my mother, who all took care of me in various ways, and my grandparents ran an antique business. And so I grew up at antique shows in malls in the city, all across really the GTA, and not just antique shows, but flea markets. I'm a flea market kid. And so, yeah, I would have been, if you ever go to a flea market now, like that 8-year-old who just sits there and looks cute and tries to get people to buy the things at the flea market. I think I did okay.
Wow, what a story. I had no idea. So that group that raised you, did any of them tell you that they wanted you to be a lawyer when you were growing up?
No, so that's the thing. I was did not know a lawyer. I don't think I certainly did not know a lawyer. I barely met a lawyer. I don't have any recollection of meeting a lawyer before walking into law school on the first day. So for any of those people who are listening about whether you can succeed in those circumstances, 1000% you can. It's a little bit terrifying, but I'm not going to suggest it's easy, but you absolutely can do it. I wanted to be, I think somewhere in my treasures, a word that Tom Curry uses often, in my treasures at home, like the things from elementary school and high school, I have a piece of paper from like the career course you take. Now they take it in grade 10. I think maybe it was younger when I was in school, and back then it was a dot matrix printer. I don't know if you were old enough to remember the dot matrix printers with the like little
I'm old enough.
the little holes on the side. And so I have a printout from the printer about, you put in your various aptitudes and everything, and it says like what career you might have, and mine was lawyer. Although another weird fact about me, I did not have a TV growing up. So my grandparents had a TV, but we didn't have a TV in my house. But one of the shows that I did get to watch from time to time when I was permitted a TV in a house that was not my own was LA Law. So, I don't know if it was that. Also, Eddie Greenspan's book For the Defense was inspiring to me. And I just wanted to be a lawyer. I wanted to be on my feet in a courtroom. I had no idea what I was talking about, obviously, because LA law is not a good representation of what it's like to practice law, just like suits or other things are not a good representation. But I imagined that that's what I wanted to do. And then it all sort of worked out in the end, even though I had no idea what it meant to be a lawyer.
Did you like law school?
I loved law school, but I will confess that I don't remember really very much about my classes at all. That the highlight from law school was working at the clinic. So I went to Osgood. I was a division leader at CLASP and the criminal division. I did more trials in those few years at CLASP than I think I did in the first many years of practice, because it was criminal law. And boy, did that ever just make me want to do more of that.
Did you make a lot of friends at Osgood?
Did I make a lot of friends? Yeah. I mean, it was one of the things I loved about Osgood is there's room for everyone, right? It's not, and I don't know about any other law school because I didn't go to one, but it was small enough to be a community and big enough to really have just a really interesting mix of people.
Was Alan Young already a crim prof at Osgood at the time?
Yeah, Alan Young was there. Yeah.
Did he teach you criminal law by any chance?
Did he teach me criminal law? So that's a good. I told you I don't remember any of my classes. I just
I remember his class. I went to Osgood too, so and he was my criminal law prof. Interesting. Well, you obviously did well in law school.
I did okay. I wasn't the gold medalist or anything, but I did just fine.
Well, not everybody gets to be Andrew Bernstein, so it's all right. But you did well enough. You summered at Macmillan, which is a big firm, and then you landed at Lenczner Slaght in May 1998 as an articling student.
Correct.
Tell me about how they recruited you. Tell me about how you applied. Tell me about the whole application process for that articling job. Was it nerve-wracking?
So recall that this firm was founded in 1992, so it was just 6 years in to the firm's existence, and it was, I believe, the first formal student recruitment. Like, it was like with the cocktail party and everything, and we don't do those anymore. But that classic thing. And I was the third articling student. So as it happened, a friend of mine from undergrad, I went to Queen's, was working as like an intern, kind of like not a formal summer student process, but because there was not a lot of formality of anything at the firm at that time. And she was like, I work at the best litigation firm in the country. And I was like, sure you do. Like, what are you talking about? And then back at Macmillan, like, I wanted to be a litigator, and Macmillan was great. Let's be clear. I have very fond memories. Justice Marcus Conan was the head of the student program at the time. And I had a great summer. But I wanted to be a litigator. And so, and by this point, I'm actually starting to learn something about the practice of law and law firms. And, before the summer student interviews, I had no idea what law firms look like. Like, the idea that I went into those without doing all my research, and I found law firms generally overwhelming when I did those interviews. The idea that I landed a job to this day is shocking to me. But by the time I was then applying for articling positions, I thought, okay, I want to do litigation, and are there litigation only places? And there were, and so I applied. And so then I asked some of my colleagues at Macmillan about this Lenczner Slaght place, and they were like, yeah, those guys are amazing. So I thought, okay, well, maybe it is the best litigation firm in the country. Maybe she's not exaggerating. And I interviewed, was through the first formal student recruitment process at Lenczner Slaght, offered the job. And you know what I did to them? I told them I had to think about it. Oh my God. Yeah, I asked my mother. Here I was on this Bay Street firm that people had heard of. And from my perspective at that time, here was I was applying to what I understood was a high profile firm with amazing people. But I know students listen to this, so I want to be careful. But law students don't know. I didn't know anything. I really didn't know anything about anything. And I guess I had some sense that I didn't know anything about anything. So I was worried about making the decision. And my mother, who was sage, was like, why not? Like, why not? If this is what you're hearing, I know you like the other place, but if it's going to be even better potentially, then go ahead and take the risk. What I then imagined was a risk, which was not a risk, even a little bit. And so I took the job, but I just made Ronald Slatt wait a bit longer than he might have appreciated waiting before I told them.
At that time in 1998, was everyone at Lenczner's McCarthy's alumnus or alumna?
No, so the obviously the 5 original partners were there. Ann Posno, who was one of the first people to join the firm after the original 5. We had now Justice Peter Osborne was here, who had come from Goodman's. I think both Peter and Ann were from Goodman's. Risa Kirschblum, who had clerked at the Court of Appeal. So this was her first place after clerking at the Court of Appeal. Tim Gilbert, who's now obviously the founding partner of Gilbert's. I spent my articling year doing a trial with Tim. some very good memories of that as well. Who else was here? Louis Sarabia, who's a partner at Davies now, and who am I forgetting? Larry Thacker, who remains a partner at the firm. And Linda First, who's also no longer a partner with the firm, but they were all associates. So the first, I think Tim and Linda became partners of the firm in my first year. But it was, we were all, well, I mean, I wasn't an associate, I was a student, but it was the 5 founding partners plus a group of associates.
How long was the trial in your articling year?
Oh, like 9 months. It was a very long trial. And we lost, we won, and then we lost in Rodero versus the Royal Bank of Canada is the leading case for you can't win a case on the basis that if you haven't pled. Justice Spence made a finding of liability based on a theory of the case that we hadn't pled, or I think argued, to be fair. Court of Appeal didn't think that should work. I think it's still the leading case.
So they exposed you to trials early on. What did you do as an articling student in that trial? Did you take notes? Did you do legal research? Tell us a little bit about your work there.
As an articling student on the Rodero trial, I did everything. I mean, for sure, if it had been permitted by law, I would have done a witness, because poor Tim did every single witness. So, I mean, I can't get my head around what that trial would have been like, but it was me and Tim. It was just the two of us in a massive trial. I took notes. I did the legal research. We met with the clients. It was a very close relationship with the clients, prepared the witnesses. Honestly, to some extent, nothing different than I do today, except for I actually today will do the witnesses. But Tim and I were a team. I felt like we were a team. I think he would say that. I don't know, you'll have to interview Tim, but my memory of it was we were an unstoppable team. I mean, eventually, unfortunately, stopped, but it was quite the experience.
Well, they still can't stop you. You're still going. So
you can't win every case, unfortunately.
Well, every loss is just a step in a long game where at the end you still win.
Exactly.
And I heard you say that the trial took 9 months. The articling term is 9 months. Does it mean that you did nothing but this trial during your articling?
No, I did other things, and I extended my articling a little bit because the trial just kept on going and going. I remember it was actually an Alan Lenczner case that he dumped on Tim, because that's dumped in the nice way. And I'll never forget the day we were walking up to court, and he said, okay, and he was telling me about the case as we were walking up to court, and I knew nothing about it. And then it ended up being my entire articling year. It's what I remember the most clearly from the articling year, because it was such an intense experience. But no, I would have done a bunch of other things, supported all of the other, mostly partners. I mean, one of the greatest things about being a student and a young lawyer at that time, and it is a thing we are doing our very best to replicate, is the experience to see each of Lenczner Slaght, Roy Smith, and Griffin, how they practice, how they advocate. And I absolutely, whether it was in my articling year or in all my years of practice until today, because I still at least see Peter do work, be able to take from the way they practice and choose the things that worked for me. And one of the greatest things about seeing them practice is, even if you take Alan Lenczner and Ronald Slatt, they're very different advocates, both extraordinary advocates, but very different. And so it teaches you that I don't need to be Alan Lenczner. I don't need to be Ronald Slatt. I can be Monique Jilesen. And I don't even, like, today that means something different than it did in 1998.
Right.
But in 1998, it really, and the years that followed, it really meant something that I didn't have to model after one person. I could figure out how to be my own advocate.
From my days in Osgood and from law firm recruitment days, I remember Lenczner Slaght ads in those student publications. There was this photo of I guess of a young lawyer, maybe of a student with a venti Starbucks cup. I don't know if you remember
No,
those.
I don't remember that one.
Yeah, so it had she or he held a venti Starbucks cup, and the message was, well, yes, you will work very hard, but it's worth it. So was it always worth it? I assume you worked extremely hard for 23 years. Do you now looking back, was all of this hard work worth it at every step of the way, or did you have doubts on certain days of your career?
Oh my God. If you find a lawyer who answers that question and said, I never had any doubts, I'm sorry to say they're lying to you. Of course you have doubts along the way. Am I good enough, strong enough, smart enough, talented enough? Is this work too hard? Can I handle it all? Whatever. At some point I had, two kids under the age of, my kids are 2 years apart from each other. I had the benefit of having a spouse who stayed at home during much of that, but one still likes to be with one's children, and children at those ages have tantrums and get sick, and it's hard. It's not just working hard, it's just I'm not a huge fan of the word balance, because it's but figuring it all out is a challenge. I always say, because it's true, people ask, well, why did you stay at Lenczner Slaght? Why did you stay at the practice when so many people don't, and women in particular don't? It's in some ways a hard question, but in some ways an easy question. The easy answer is two things: one, the people, and two, the practice, the nature of the work. The people are the most important, the most fundamental. If I didn't have the colleagues that I have, even if the work was super interesting and the clients were great, but if we had some cutthroat place where I didn't get support, or I didn't have people I could go to for advice and support at all levels of the firm, from senior to more junior, then I think it would be too hard. I do think that the colleagues and the culture are they really carry you along, because if you have a bad day, or if you're having doubt, I know there's someone down the hall or on the other end, during the pandemic, on the other end of a Teams call or chat or text, who will pump me up, and vice versa, right? So one is the people, just the fundamental part of, I think, about keeping certainly myself, but other people, or people within the firm and the practice. And then there's the nature of the work. It's so, you have the same practice. It's so much fun what we do. Every day there's a new problem, there's a different kind of business. I'm like I joke about, there's a case you will find under my bio, which may not have been the most fascinating legal case in the world, mega blow molding. And I remember going to that business, and they make like shampoo bottles, like they mold bottles, and they showed me the actual equipment, and it occurred to me, like, I have no idea, I didn't know before then how you manufactured shampoo or other bottles, or how they changed them. And I learned a lot about the way they actually did their work. So whether it's the pharmaceutical industry, whether it's the manufacturing industry, whether it's the financial services industry, or in the case of our firm, I did a lot of the medical malpractice at the beginning part of my career. So, you're doing an orthopedic case or something. Like, is there any other job on earth where you can learn that much about different people and different business? I can't think of any other job on earth. And then of course there's the interesting legal problems. I actually really love the facts as much or more than the law. Don't tell anyone that I like the facts more than the law. I love the law, but I actually really think a huge part, and I think the majority of the part of solving difficult legal problems is understanding the people and the facts. And then we'll find the law that will fix the problem. But first you need to understand the facts.
This is a great insight. I love it. It's a great insight for trial lawyers. I will definitely take it away with me. So I want to go back to my initial statement about this long, unending, scrolling list of cases that you did that I found on your law firm's profile page. And we will try to understand how you work today. We will try to deconstruct you. You will be safe,
Okay.
don't worry. But I want to start with deconstructing your day. The day is a basic unit of work. It's the basic unit of success. All of these cases on this long list, they were done day by day. So tell us about your day. I want to know from the very beginning, if you work out, if you get up in the morning, if you have coffee, if you don't have coffee. Let's talk through your day. And I really want to deconstruct it, please.
So my day starts with my Starbucks. We did it in our holiday card this past year, a New Year's resolution thing, and the resolution that was posted for me was never to have my latte alone. And then I realized, of course, I always have my first latte alone because I leave my house. I stop at my local Starbucks. I say hello to my local baristas who always greet me because it's a wonderful place. I get my latte and I drive into the office. So I do have one latte alone every day, but the rest of the day, I may have multiple. My day usually involves multiple lattes, which is now a far walk down to the TD Center from our office. But that is the way my day starts. Thanks for calling me out. I have not been working out in the morning, but I should. My defense to that is my daughter is on the rowing team and I have to wake up at 5 o'clock in the morning to get her to rowing. She's graduating this year, so this is my last year as a rowing parent. And I was about to say I'm excited. I love that she does it. And so that's my little sacrifice for her is getting up and I don't know, it's a thing, getting up at 5 o'clock in the morning. Anyway, so I have been coming into the office most days since the end of the year. I find it gets me going, and I'm the managing partner of the firm. And
did they give you a better office?
I have an amazing office. So no, I didn't. And I'm the one giving out the offices, or I was fulfilling that role before I became the managing partner. We actually just renovated some new space at the firm, and that floor has all of the offices are the same size, and it's a beautiful space. And I was seriously thinking about moving down, and the only reason I didn't, and so my office would have been the same size as everyone else on that floor, but I didn't because the walls are glass as opposed to my office, which has like a door and nobody can see in it. And I figure people ought to be able to come into the managing partner's office and cry or scream or yell or do whatever they want and do it privately. So I'm in my beautiful office with a view of the skating rink at City Hall, which I find in the morning quite, I like to, there's always one or two people who just skate around like at, whether I'm here at like 7 in the morning or 9 in the morning, there is a person just having a wonderful time skating on the rink. They're getting it ready right now for, I guess the Leafs are doing a thing there on the weekend. So anyway, so far we've got to, I get to work in the morning.
With your latte still, or
with
maybe the
with my,
second
yeah,
one?
no, I finish it off here. I mean, I just started as managing partner in January, so a big thing. My days these sort of 4 or 5 weeks have been different, really, from what they were before, because I'm spending a lot of time walking around the office, having lunch, coffee, drinks, breakfast with all of my partners, with members of the legal community. So I'm just, yeah, I'm spending a lot of time doing that in the first 90 days of this role. It's been great. But also then having conference calls with clients and reviewing factums and all of the things that one does as a litigator.
Did Tom Curry give you any advice about being a managing partner when he passed the buck to you?
Oh, Tom Curry has been giving me advice since the day he walked in the door in 2002. And he will continue to give me advice for the rest of our natural lives, I'm sure, and I mean that in the nicest possible way. So Tom and I have worked together. I actually preceded him on the management committee, and we, I mean, all of my time on the management committee has been a great team, but of course, Tom and I worked very well and very closely with each other. Tom's catchphrase is, well, he has many, but one of them in respect of the firm is positive, 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 or work hard and have fun. And it really is the positive, positive, positive that stays with me. He has delivered a feeling at this firm of endless positivity. I mean, his charisma is unmatched, but and we all have to lead in our own ways, but that positive attitude he has is definitely a thing to emulate.
Okay, I want to dig a little bit into some details of your day. So, and you already said that your day has changed even in the last several weeks. Of course, it's also changed over the last 23 years. In your articling days, you were in trial a lot, and then you were probably in trial a lot, period, over the course of your career. Let's start by talking about the categories of days that you have. So I assume you have a trial day. That's one category. What other categories of days do you have? Maybe an urgent proceeding day or something like that. Maybe a business development day. Can you talk about that?
Yeah, so urgent proceeding days would be my favorite. Well, after a trial day, probably trial day comes as the #1 favorite, trial or appeal day. And then I mean, one of my favorite things to do is injunctions or any sort of real-time litigation. And so, if someone calls today and says, we need to bring an injunction for this reason, and it's super urgent, and we need to do it on Monday. So, okay, I mean, whew, it's an adrenaline. You get that adrenaline. Someone calls right after this. Then I figure out whether that's, you run your conflicts and you figure out whether you can actually ask all the questions to make sure you can help them, because you're not going to spend that client's money if you're not going to get anywhere on Monday bringing in the injunction. If I got that call today, let's assume it's a commercial thing. I get that note out to the commercial list. I have to be able to describe it properly I'm not going to waste that court's time with an urgent attendance on Monday unless it truly is an urgent attendance. And that is one of the benefits and burdens of having any reputation is I'll probably get the date, but I better for sure be a truly urgent attendance, or I lose any reputation I have goes down considerably. That court's not going to be very happy with me if I've asked, they've set aside some time, move something for me, and it's not urgent. I have to figure all of that out, in an hour, because it's going to be Friday afternoon. And then assuming I haven't done it already, I send a note out, either if there's an associate I know who has time, or it's just a note out to all of the associates. Hi, everyone. Cool new case. even if it's not cool. But it's a cool case because it's an injunction on Monday, cool new case. Who has time? And then we would get together in my office and try to figure out what we need to do to solve the legal problem. How are we going to get this done for Monday? What's everyone's time? Who's going to be like, do we need an expert? How are we going to get that? When are we going to meet with the clients? And then it's, meeting with the clients, drafting the affidavits. Who's going to do the legal research? Do we have precedents already? Let's get our research team on it. And as much as I get an adrenaline rush out of the courtroom, some like an injunction like that, I have an adrenaline rush from the time the phone rings to the time we're arguing it, and then and I actually I know it's comical, but for me that's kind of a really fun weekend. I mean, I wouldn't want to do it every weekend, but I do love that stuff.
The team discussion to me makes it fun. I work with teams also, but nowhere even close to having a team such as your team. But so I'm curious, what is the average size of the team on a significant, very serious, urgent injunction like that? Though, how many people gather in your office on that day?
It really does depend on the case, which I know is an annoying question. There could just be, if it was a manageable one in terms of number of witnesses and everything, it would probably be one associate. We'd get a student. Maybe we get someone from the research team to support. How many documents do we have? Do I need a clerk? So it could be that. But some of the injunctions I've done that are more high profile than others, the Cleveland team, the Freedom Convoy one, there's a lot of people on them, and in part because they're fun and high profile and everyone wants to help. But those cases you might see a dozen people on it. We got to do something in 36 hours, and let's just we on the Freedom Convoy case, we had a facts team and a law team, and then we had someone dealing with the expert, and we put it all together. And even then, there was you don't get it done in the 9 to 5 business day.
Right. So where do you spend your time during days like that? Are you the mastermind? Are you delegating the tasks, or do you actually draft things, or or maybe you don't draft anymore? Maybe you just delegate. So can you describe your role in more detail?
I would say it's a little bit of all of the above. I'm not doing the first draft. I'm definitely still doing drafting. That executive summary, that's really important. I also have experience doing these cases, so I want to make sure, read it and understand it, and make sure. I think that if we make that pitch, the the judge is going to catch it, and so I will reframe things. I think that's true of if I'm working with Peter Griffin on something today, and an associate is drafted and I read it, it goes to Peter. He's going to redraft. Like we are all very committed to the legal writing and have our own ways we like to deliver the message. So definitely involved in the drafting. Just thinking about that Freedom Convoy case, I was probably not in the weeds on anything, but involved in everything. So I don't know if it's mastermind is the right word, but I worked
editor-in-chief.
Yeah, I worked day and night, just like the team. Like it wasn't just over to you, but it's like, where are we on this? And have you thought about that? And I don't know, maybe it was a very frustrating oversight, but it was really oversight over everything, as well as just sort of bringing my experience to bear on doing. I mean, there's no case exactly like that, but doing injunctions and Mariva injunctions in particular before.
When did you stop doing legal research? Do you remember that time in your career?
I mean, I still, when did I stop doing legal research? I would say you don't ever totally stop doing legal research, right? Someone's drafted a fact and I read it and I say, like, let me note up that case, or I'll read this, or does that work? And, you know, I wouldn't rely on Canley to start my legal research. I mean, but I definitely open Canley a lot to sometimes just to search around to see, you know, how we all hate that case that has the proposition that you like, but it's the wrong result. I'm like, oh, come on, can't we find one that has this proposition but comes to the result I'm looking for? I will annoyingly do that sometimes, but when did I stop like actually writing the legal memos? I don't know. It's funny, like you think I'll never stop doing this, and then one day you stop doing it. It's been a while. I'll admit it's been a while.
Interesting. What software do you spend most of your day in? Or maybe we can break it down by percentages.
Oh, I don't know. So I spend more time than I like on Outlook in my email. I wish to spend less time. I think I feel like I'd have a lot of people on side of, is there a way I can spend less time just going through my email? Teams, a lot of time on Teams. So we have a very, not just the calls, but we have a very active Teams chats at the firm. We do a lot of, I would say, both social and problem solving in Teams. Like if I were on a conference call with you right now and you were a client, I might be chatting with my colleague on the file just to say, like, can we find that document, or did I get that right? That's one of my favorite questions. Okay, I just said, was I right about that? You know, that's another question you might ask. There was a time where I was the person who knew everything about the file, and now other people are playing that role, and I'm not comfortable with it. So I have amazing people I work with who you know every last thing, but I still want to check with them that I'm right when I say something to a client, obviously. So Teams and Outlook, and of course we have our docketing system, but I don't spend, you know, you use it, I don't spend time on it. I use, I like my iPad. I prefer to read on the iPad than on the screen. So I have various readers which I use. Which one is the one that's open right now? Goodreader, not Goodreader. Anyways, various PDF readers.
PDF, yeah.
That I use for reading. It's much, I don't know, something about it being flat instead of up here actually makes it easier to read. Yeah, those are, I would say those are the main ones.
Not a word about
Oh,
Microsoft
Word. Yes,
Word.
yeah, I guess.
Not a word about Word.
Yes, yeah, you know, you're right, Word. That obviously that as well. I am definitely now more reviewing the work of others than drafting it from scratch.
You talked about your team, your beautiful, wonderful, helpful, amazing, intelligent team. What do you think about opposing counsel? Let's gossip about opposing counsel.
Let's gossip about opposing counsel. I think that actually the best thing that can happen on a case is that you get amazing opposing counsel, right? Like the better the opposing counsel you have in terms of their talents. Usually if they're very talented, they're also quite kind and wonderful to deal with. And you know that it's a fair fight, right? Like, you know, that this is going to be good. I might not win, but that, and I'll be able to tell my clients exactly that we're actually blessed with an excellent lawyer on the other side, which they don't always get, but that's what I'm always looking for. And of course, I have a million friends in the profession, and I hope they feel the same way. So I would say it's hard to estimate the percentage, but we'll say 95% of the time, opposing counsel are great. That 5% of the time that they're not, I find that really frustrating. I don't like that. I hate dealing with, and I'm bullshit. I don't have time for it. I don't like refusals motions even. I don't like people trying to stake the claim for something. I don't have any time for it. So and it's easier as you get older to just be like, I'm not doing that. So one, I don't know if I should tell you my, so there's two things that I've done. One has been for a number of years, and one's more new. So there's a book called How to Talk So Your Kids Will Listen. I recommend that as reading for any, if you don't have kids, doesn't matter. Read it, and it helps you learn how to talk to lawyers who think a lot of themselves. Lawyers who think a lot of themselves are, or all lawyers, are very much like children. And if you talk to lawyers, if you need to learn how to deal with them, read How to Talk So Kids Will Listen, and it will help you, I promise. And then secondly, I've learned how to just treat every lawyer like they're my best friend. And so this is a thing I maybe shouldn't give away, because of course, so many of the lawyers, like, remember, 95% of the lawyers I deal with, I actually love working with. And so I'm not faking it. 5% of the lawyers I'm dealing with, I'm kind of faking it. But if you're not screaming at them and not fighting with them, and you just say, oh, like, talk about their day, and it doesn't matter how mean they are to you, you just pretend like they're not being mean and you're nice, they actually stop. It's the weirdest thing. I just try not to let people be mean to me. I actually think it's much easier. That wouldn't have worked 20 years ago. I'm not recommending that. Well, I mean, I would recommend, of course, to young lawyers to be civil, and to try to let the abuse, which I'm sure people still get, not get to them. It's not them. Throwing on the charm and trying to, I think it's my seniority and reputation helps in that regard. But it sure does make my life easier. I sometimes roll my eyes to the back of my head after one of those calls, where I've been really nice to a person who's been really mean to me, but at the end of the day, seems to help.
Yeah. This is great insight. I want to talk about commercial trials now. And they are different. They are document intensive. They changed because of the pandemic. They are more often on Zoom now, I guess, than other types of trials. So can you take us through your trial prep, a bird's eye view, and then we'll talk about the trial itself?
The trial prep. So probably everybody has these, but like we have a trial checklist at the firm. I'm like, okay, so like now we're however much far away we are. So like all of those things that you might forget to do. Have we answered all of our undertakings? Have they answered all their undertakings? Is that a refusal I want to maintain, or is that really going to hurt me in the long run? What is my actual theory of the case? Has it changed? No, but you laugh, but it's true. You drafted the pleadings however many years ago. You had the discoveries, all the answers, the undertakings. Maybe I have a new theory of the case.
Yeah.
Maybe did I plead bad faith? Like maybe now that we've had the discoveries, I can actually make a good faith argument that I hadn't thought of. So do I need to amend the pleadings? And it actually takes a lot to do all of that work, because who has the time to just stop doing all of the like 4,000 emails you have to do. The trial's not tomorrow. It's 6 weeks or 8 weeks from now or whatever it is. And I have to just say, like, okay, we have to stop and just go back to first principles. What is this case about? What is the evidence in support of the issues? What has the law changed? And so you need to stop, figure out what the time is where you stop and you just like look at your whole case as a whole and make sure it's in order to do all of the, like, that's before I've prepared a single witness or done anything. Just is my case the case that I had when it was issued or when I first defended it? Is there anything else I need to is there anything else I need to do? And then then really it's people say this all the time, but it's true. What am I going to say in my closing?
Yeah.
It is really where you should start, because then that helps you know what evidence you need to call to make out the claim or the defense. So do I have all the witnesses I need to do that? So if you can really do an like, I'm not going to write the closing. Obviously, I make myself sound a lot more prepared than I feel sometimes. But if you can do an outline of what that closing will look like, and I like to think about doing it out loud. Right, Your Honor, you've heard evidence from so and so, and they've said this, and that makes out this cause of action. And if you think, okay, I'm not going to be able to do that, my client's not going to say that. Where am I going to get that evidence from? What are the documents that support those things? And then from there, you can go back and create the joint document brief and prepare the witnesses and, prepare before you prepare the witnesses, figure out what documents you need to go through with all of the witness. I mean, again, a cliche, but preparation is everything in terms of trials.
Is there a lot of duplicative work preparing for trial that duplicates work that you did during discoveries, drafting pleadings, and so on and so forth? Is it normal for lawyers to do the same work twice or three times sometimes, because this is just the way things are, or is it not that common?
I guess it depends on what you mean by duplicating work. If I'm like, if, as I've said before trial, you look at the pleadings again, there's a lot of things have happened since you first drafted that pleading. You've produced documents, you've received documents, you've done discoveries, you've answered undertakings. You know a lot more, both good and bad, about the facts of that case than you did when you drafted that pleading, the claim or the defense. So I don't think it's duplicative that I'm looking at the pleadings again. It's also not duplicative, particularly, that I'm looking, I've got memos on our document management system about the causes of action, but maybe they were written 3 years ago. And so has the law changed? Are there new cases which support our, just on the facts which support us? I mean, you can't just interview the witness 2 weeks after you're retained and not do that probably a dozen times between the time you get the case in the door and before you go to trial. So yes, we do the same thing more than once, taking that as an example, interviewing key witnesses. But I would argue it's not duplicative. It's just part of the iterative process of advancing a case.
I'm jumping out of trial a little bit for a second. You started your career with a trial that in a case that was ultimately about the importance of pleadings.
Ultimately.
Yes, well, ultimately. And my question for you is very simple. Do you think pleadings are still as important as before? And should they even be that important as they seem to be in civil cases?
I mean, I think I mean, it is notice to the other side about what your case is about. So yes, we absolutely should do pleadings. Otherwise, how would we know the parameters about what the dispute is about? And at the end of the day, the rule is shall amend. And so the pleadings rules don't prevent people from advancing the merits of the case, because really, unless there's a material limitation period issue or a new party or something like that, unless there's some real prejudice, which you don't see very often, a party has a right to amend their claim really right through the course of trial. Now, that's frustrating when it happens in trial because it defeats the notice purpose, and there may be a higher likelihood of prejudice at that time. But for sure, pleadings are important in terms of framing the issue. And I'm not a judge, but I would have thought it's also important for the judge to understand what it is the parties are having a dispute before them.
Do you see a lot of bad pleadings? Badly drafted pleadings?
I would say in my practice, I actually don't. I'm blessed of having a practice, usually, again, 95% of the time, where the lawyers are excellent. So I would say no, I don't really see a lot of badly drafted.
That is a blessing. We don't have much time to talk about trials in great detail, but I want to ask you about the role of evidentiary objections in commercial trials. Can you talk about that?
The role of evidentiary objections in commercial trials. So people say that civil litigators and probably commercial litigators don't know anything about evidence. I would say that the judges definitely try to keep us honest and following the rules of evidence. And some of the evidence goes in and some of it doesn't, and the Court of Appeal will call us on it, or call the trial judge on it if it's material. We can be one thing we do in commercial litigation, or again, it depends on the lawyers and the judge. Probably not entirely consistent with the rules of evidence, things like marking an expert report as an exhibit, which I actually don't agree with, but those are things that happen sometimes just in the normal course. Again, in my practice in commercial litigation, a lot of things are agreed upon. Sometimes that can be dangerous, and the Court of Appeal has addressed this, right? Like, what does it mean that an email is admitted for the truth of its contents? That's a bad idea. Actually, because if the email says like records an impression that someone had, it doesn't, are we really recording the email is it being admitted for the truth of the contents, or just that email was sent and received? And so I do think civil litigators need to think more about how evidence actually works. On the other hand, I really do appreciate that for the most part, we resolve things like business records. Like, people don't fight about, most of the time, about business records, because they're going to get admitted, because the steps you need to go through to prove that the financial statements are the financial statements of the company. If there's no dispute about it, like, why are you fighting? Why are you fighting about it? So there's, I think, a balance that can be had in civil litigation, but the rules of evidence, I do believe, are important.
Our 1 hour passed in a blink of an eye. I don't remember an interview where I just lost track of time, and then I wake up to reality, and boom, it's 1 hour is up. And so much, you said so much. You shared so much in this short hour. I think this interview is going to become one of the coveted sources of information for many lawyers. I thank you so much, Monique, and I really enjoyed talking to you. I hope we can continue this conversation, maybe in a part 2 sometime.
Absolutely. Thank you so much for inviting me.